Hello, I'm Henry Quillian. I'm here doing litigation fundamentals with Henry Quillian here at Taylor English with a lot of my colleagues, both in person and online. We are doing this as a public service in a sense to discuss various things that need to be taken into account when doing litigation. However, we are not here to provide legal advice to you. So you need to turn to your individual counsel if you're involved in litigation. If you don't have a lawyer, go get one because we are talking about a lot of technical things relating to presenting matters to the court. We are here to discuss the ins and outs and try to get the best practices, avoid do-overs, etc. in connection with civil litigation. The focus of this topic is responding to motions for summary judgment in state and federal court. Specifically with respect to state court, we're talking about the state courts of the state of Georgia, both state courts and superior courts. And also we will focus in on responsibilities in responding to summary judgment in federal court. I'm going to do a brief review of last month's presentation so you'll sort of get reoriented where we are and where we've got to go. I made sort of a list of things that we covered last month, one of which was the hypothetical with two payment streams going to two creditors but received by a single person who was more or less the bursar for these two creditors, where we had one note that was usurious and illegal and the other one that was legal, but there was a question as to who owed how much money and how you might respond to summary judgment with respect to each note. There were lots of potential for questions of fact relating to the flow of the cash, especially when you had some of the money being applied to a usurious note, some of the money being applied to a different note, and only a single person getting the money and just dividing it up as it came in from defendant. We also went over the burden of the movement on summary judgment, the burden of the respondent in responding to summary judgment. We talked about the timing of when summary judgment can be filed and when it can't be filed, and what the limits are on the timing for summary judgment and response. We talked about this new questionable rule regarding responding to summary judgment in Georgia, whether it's 30 days or 33 days based on some appellate cases that have come down. And we'd also talked about the type, competence, and means of establishing evidence necessary to give rise to a genuine issue of material fact. For instance, is the witness a competent witness to testify about what they're testifying about? Are they competent at all? Is the evidence subject to authentication or not? In other words, is you just throwing a document in, or you actually have some authentication of it? We also talked about the business records exception to the hearsay rule and what you would have to do if you don't have if your witness doesn't have personal knowledge of the business records, what they would have to do in order to provide an affidavit or other testimony based on business records that they don't have personal knowledge of in order to get them into evidence, give rise to a genuine issue of material fact. But what we did not discuss was the technical details relating to all the filings and responses to summary judgment. What do you actually have to put together, file with the court in order to properly respond to summary judgment and hope that you can win either on a legal basis, which is not, there could be endless numbers of legal reasons why the movement couldn't win summary judgment. They might be completely wrong on the law, or in our hypothetical, the note might be usurious. And so that might be a legitimate reason why, if they move for summary judgment on the usurious note, then they shouldn't win. Or giving rise to a genuine issue of material fact for trial. We talked about what's genuine and what's material last time around. So today's topic is the rest of the story, which is how do you get a response put together that actually is going to work and to stick. And as we have always done in Quillian's kernels, one, this is interactive. Secondly, what do we do to figure out what the basic things we need to do are? We need to read the rules, right? So with respect to state and superior court, what rules apply? Well, the highest level rule would be the Official Code of Georgia 91156, which is the summary judgment rule. It states what the standards are and what basically has to be done. And then also, as we know, there are uniform superior court rules and uniform state court rules. And in this instance, they're, I think, exactly the same. And that is Uniform Superior Court Rule 6.5. So let's just throw it out there. If you're responding to summary judgment, what is the highest level name of each document you need to file in order to respond to a summary judgment motion?
Brief in opposition.
Okay, a brief in opposition. Anything else?
Any supporting affidavits that would establish genuine issue of material fact.
Okay, so it'd have to be some sort of admissible evidence, whether it be affidavits or anything else that would establish a genuine issue of material fact for what? For trial, right? And then what would be another document that you have to file?
The response to the movement's statement of undisputed facts,
Okay,
or rather, the respondent's own undisputed facts.
okay, or the facts by the respondent that are disputed material facts, right? So let's go, because we didn't discuss this last time. The movement will have to have filed a statement of undisputed material facts as to which form the basis for summary judgment. And they would have to, what else is also included in that document?
Theory of recovery.
Theory of recovery. Exactly right. And at least according to the rule, where is this document supposed to be in the stack of documents that the movement has to file? It actually says it's supposed to be attached to the notice of motion, even though it's supposed to be a separate statement of material facts. Who actually sees them attached to the motion document? I don't either. I usually just see them as a separate document. So I don't know what to do there, except for I've never had any body say, oh, well, it wasn't attached to the notice of motion, so a legitimate motion. I think it's sort of helpful to have it as a separate document. And that document is supposed to contain what? It's called a statement of material facts as to which there is no genuine issue. So what is it supposed to contain?
Undisputed fact.
Okay, facts as to which there are undisputed, yeah, no dispute. And so theoretically, those facts would be sufficient if undisputed and if the law being presented by the plaintiff is correct to justify I should say the movement rather than the plaintiff, to justify on the movement's behalf summary judgment. So in our hypothetical, if there was no dispute over the amount of the application of the funds to the non-usurious note, theoretically the movement, the creditor could say, this note was executed, we received these payments, it was in this amount of money, we didn't receive these payments, the interest rate is this amount, this is how much is due, and they should be able to win that motion for summary judgment. I sort of set it up so there would be a mishmash of facts relating to how much actually got paid so that there could potentially be a denial of summary judgment. But as the respondent, do you have a responsibility to file a statement of defenses? No, not under the rules. The local rule, Uniform Superior Court Rule 6.5 says the response shall include a separate, short, and concise statement of each of the material facts as to which it is contended there exists a genuine issue to be tried. Now, in some of our commercial cases, is it easy to make the statement short and concise? I see some laughing. Why do you laugh?
I don't think it's easy.
Okay. And that is because of why? Well, it's because in a lot of our cases, you got 10 people testifying differently about the same thing, but they might all agree on the genuine issue. But then also sometimes it's a very complex fact pattern that winds down to the specific scenario that might give rise to either defeating summary judgment or granting summary judgment. So the rules are a little bit don't necessarily meet complex litigation, I guess one way of putting it. And if you did file a statement of undisputed material facts in the state court under the Uniform Superior Court rules, you have to cite a citation to every fact in your statement of disputed facts. See this.
I remember that my recollection is that you did, but I could be wrong.
You have to definitely give a citation somewhere to every one of those disputed facts. I think a lot of people just list the facts in their statement of disputed facts, and then in their brief have a very pinpoint citation to the evidence that gives rise to the disputed facts. What is the general consensus in the room about whether the statement of disputed material facts has to have a citation?
Sure, that would be better.
That's what I always do.
You think it's better? Doc?
Well, I don't know what it has to do. I mean, I'm in the practice of listing the evidence, the material facts, and then in the brief, I don't normally cite to the evidence again, but I would cite to like statement of facts response number 13.
You say you normally do cite the statement of material facts, or you don't?
I'm saying in the statement of facts itself, I'd list the evidence, but in the brief, I would normally just cite to the statement of facts like by paragraph without repeating it. But I've seen a federal judge's standing order saying she wants citations to the evidence in the brief too.
Okay, in the federal court? Yes. Yeah, we're going to dive into that. What can judges do? Raises a good question. Can judges say they want something different more than rules require?
Yeah.
Yeah. Because who gets to decide this motion? The judge. So what do you have to do if you want to win?
Accommodate the judge.
You have to do what the judge wants. And what can that, we discussed the Bedford brief in the last session. What did I say the Bedford brief was? That was where Judge Bedford of the Superior Court of Fulton County used to want you to attach a copy of every case that's very important to your brief as well, which is certainly not something that was in the rules. So we have a little bit of a discontent or discord here about whether the specific citations to the evidence should be in the brief or only in the statement of undisputed material facts, but then references in the brief to that statement of disputed facts, or whether they can be in both. And it sort of depends on what you are doing. I don't think in state court for the entire time I've been practicing law up until I got to Taylor English in a state court action did I ever cite to the statement of disputed material facts as being the place where a judge is to go to find the disputed facts. They were always in the brief, and unless it was a humongous problem, the relevant evidence and affidavits and everything were attached as exhibits to the brief, so that back in the physical days of briefing, a court could pick up the one document and not only check the citations while reading through the brief, but also could, without having to go back and forth between documents. Dorothy, you are from a different firm, and so that's one of these things. This whole thing got started when we had a lot of people coming from different firms with different ideas of what should and should not be done. What does your group typically do?
Definitely, without a doubt, how I write a summary judgment motion, including the evidence, is cited in both places because you want the reader, the judge, or the judge's law clerk or staff attorney to be able to quickly and easily find what you're citing to.
Okay, so the whole point is exactly what you said. The whole point is for them to definitely be able to find what you're citing to. It does not hurt. Put it in the statement of disputed material facts if you're responding, or the statement of undisputed material fact if you're moving. It does take, well, it used to be, there may be a way to not spend as much time by copying and pasting, starting in one place and copying it to the other. But at least you can do it and make sure you do it with precision, so they're not looking at the wrong page or looking at the wrong document or whatever the case may be. All right, so and as both Don and Dorothy have discussed, you have to say what the fact is, and you have to say how it's supported by the evidence and where the evidence is in the record, so that the judge can find it. Do you have to have everything on record that you're relying on to give rise to a statement of disputed fact? Say no, you don't have to have it in the record.
You said one record. What do you mean by?
No, in the court's records.
Oh,
Yeah. Okay, yes, you do. If you don't have it there, the judge is going to act as if it doesn't exist, or the other side will come forward and say, yeah, that's sure nice that deposition said that, but nobody filed the deposition. Okay. Can you just submit a document without authentication as a basis to defeat summary judgment?
Probably not.
No, you cannot. You would have to need to cite the way in which that document is authenticated, whether it be by affidavit or deposition, or by response to request for admission, or if it's specifically addressed in interrogatory response and specifically detailed, such as a Bates number in an interrogatory response. That might be a means by which you could identify it for the record, so long as both the interrogatory response and the document that's referenced is placed in the record before the court. How about this? If the interrogatory response just says under Rule 911-33C, just says, in response to this interrogatory, the respondent is producing documents, and it's the burden is equally on the respondent as to the requester of the answer to this interrogatory to determine what the answer is. Can you just take the stack of documents that they referenced and put it into the record? No. What would you need to do in order to, if you had that stack of documents, let's assume it was accounting records for, 5 years of a note, and they were saying you can calculate what was paid just as easily as we can. What would you have to actually put in there if you wanted to defeat summary judgment?
Their math showing that your number is right.
Okay, so you need to have a person review these records
Somebody review it.
and come up.
This is it.
And what would be the credentials of this person?
depends, maybe just maybe common sense.
Okay, yeah, so I counted up all the deposits and subtracted all the subtractions, and this is what the balance is. It doesn't necessarily have to be an expert, depending on what the subject matter is. If it was an antitrust case, on the other hand, they were trying to give some very detailed response about the correlation of, I don't know, two sales streams or something, you'd have to have an expert. Okay, so essentially, you've got to apply in your response to a motion for summary judgment. You've got to make sure you have evidence the judge deems to be competent in order to defeat the summary judgment motion by giving rise to a genuine issue of material fact for trial. Okay.
And that's an excellent point. About 2 months ago, I had a motion for summary judgment hearing, and the other side had about 6 subcontractor witnesses, and he had an affidavit, but he didn't respond to the motion for summary judgment. And he learned very quickly, because his lawyer withdrew, so he's pro se, that you can't do that. You can't bring in new evidence if you fail to respond to the motion for summary judgment. You have to respond to it, and then you're limited to the pleadings and whatever is actually in the record.
Oh, so you can't have a bunch of people testify in response to summary judgment?
Nope.
All right, how about this? We did cover this last time. When's the last time you can, the latest time you can submit evidence to defeat summary?
Day before the hearing.
The day before the hearing. Is it 24 hours or is it the day before?
It's the day before.
It is the day before. However, as Riviera knows, the argument the other day, about a month ago was, oh, it has to be 24 hours in advance. I don't think the rule supports that. Where we got a non-party witness's affidavit who had been giving us round in circles. We got it and filed it the day before, but it was like 23 hours before the hearing, something like that.
Isn't there a provision that you can have oral testimony at the hearing if the court permits it in advance?
Does anybody know such a rule?
I thought that was in the
There's the rule we talked about regarding partial summary judgment allowed, which makes me very nervous. It allowed inquiries of the lawyers, interrogation of counsel under 911-56D. But I'm not aware of the court being allowed to take testimony to, at least not to grant summary judgment. Anybody aware of such rule?
No.
Okay, I'm not aware of anything else.
I think I mentioned this last time, but I have had a judge do that.
Yes.
There was no reason to appeal because we won, but nonetheless, that it's something, there's no rule that permits that, but so we were a little bit taken aback when that happened.
Yes, I would have been objecting but not telling the court to go to hell and you can't talk to my witness. But that, as far as I know, is completely inappropriate on a motion for summary judgment. I don't know whether if there's a TRO motion or something like that, and the judge was very concerned about what the real facts were. Perhaps in that scenario, the judge could ask questions, but on a motion for summary judgment, I don't think that's correct. And I would object vehemently, especially if I had nailed down everything perfectly and the other side had failed to put in the necessary evidence. Okay. A topic we did not get to last time was, what if the other side's moved for summary judgment and they've cited deposition testimony to support the motion for summary judgment, and you submit an affidavit that contradicts the same witness's testimony about the specific fact that's supposedly undisputed upon which the movement is relying to get summary judgment entered. What rules apply to that?
You have an issue of material fact, and the summary judgment motion should be denied because it's up to the trier of fact to decide that issue. It has to be a material issue.
Okay, what if the same witness testified contrary to to the affidavit you submitted while at deposition.
They created the issue of fact.
Well, there's some case law on that, both in federal law and the state law. It's called the rule and prophecy in the state court, Georgia state court system. And it's prophecy, Prophecy, like a prophecy corporation versus Charles Rosenwald, Supreme Court of Georgia, 256, Georgia 27, 1986. And it basically says that, that if you try to contradict your own witness's testimony using an affidavit, then unless a reasonable explanation is given as to why the affidavit testimony, a reasonable and believable, I guess, explanation is given as to why the affidavit testimony contradicts what appears to be the deposition testimony, that the affidavit is ignored for purposes of giving rise to basically denial of summary judgment, and the person who is relying on the deposition wins. And similarly, in
Excuse me, Henry, doesn't that rule only apply to plaintiff's testimony?
excuse me,
I believe that rule only applies to a plaintiff's testimony. It wouldn't apply to another witness. Is that right?
ooh, that's a good question. I do not know the answer, whether, just so everybody hears, whether that only applies to a plaintiff's testimony. I am not aware of it being restricted to that. Do we know if there's a subsequent case or?
Well, I mean, there've been a zillion cases on property over the last 40 years, that's for sure. I mean, it's something that came up actually in some briefing I'm doing right now. I believe that's. I can't say.
So if you were relying on the Prophecy Corporation rule, make a determination as to whether the party that is seeking to give rise to a genuine issue of material fact and who has submitted both deposition testimony and contradictory affidavit testimony, whether the person is the plaintiff. And you better determine whether there is in fact a narrowing of the rule to apply only to plaintiffs, because I don't know the answer. What I do know is that a plaintiff in a federal court case relating to the same rule, it's Van T. Junkins, Junkins and Associates versus U.S. Industries, 736 Fed 2nd, 656, 1984, was precluded by the court from responding to the defendant's motion for summary judgment when his deposition testimony relied upon by the defendant in a motion for summary judgment was contradicted by the same plaintiff's affidavit, which said that basically a condition that was present in the defendant's argument, the plaintiff is trying to enforce a contract or an oral contract, could not be relied on to give rise to a genuine issue of material fact, where the affidavit was contrary to the deposition testimony. And in fact, the court said the affidavit was obviously a sham, which is not a great thing if you're the lawyer trying to rely on something that the court calls a sham. But it was a very small distinction in my mind between the deposition testimony and the affidavit testimony. But the deposition testimony in that particular instance, it wasn't like it was one question. It was a lot of questions circulating around a discussion the people had. And the plaintiff did actually acknowledge a number of conditions to the fulfillment of this contract. So I think the court was in reasonably good standing to make that decision. in Rule 91156, which I'm trying to put my fingers on, here we go. And under the Georgia rule, there is a 91156G relating to affidavits made in bad faith. And it says, should it appear to the satisfaction of the court at any time that any affidavits presented pursuant to this code section are presented in bad faith or solely for the purpose of delay, the court shall forthwith order the party employing them to pay the other party the amount of their reasonable expenses which the filing of the affidavits has caused him to incur, including reasonable attorney's fees, and any offending party may be adjudged guilty of contempt. So I suppose what that means is, given the existence of these rules and that rule, you need to be both aware of everything your client testified at deposition and everything you put into the affidavit for the client, and have the client really spec the affidavit. And if you don't, and if you're going to contradict your deposition, you need to have a very reasonable basis for doing that. And obviously the first stage at which you could do that would be the errata sheet for your deposition. If the client says, well, that's not what the question was as I understood it, or the court reporter wrote down my answer wrong, they need to address it at the errata sheet stage. A brief side thing, I actually got a couple divorced by the prophecy rule. At least according to the way things worked out. My client had claimed, my client's opponent had claimed she was married to my client, a common law marriage, and the court had denied him summary judgment against her based on the alleged marriage because of the way the facts worked out, and effectively held they were married. And then we moved to set aside the motion for summary judgment and cited her deposition testimony, where at the same point in time she had testified that she was not married to him and she would never marry him. And so even though she claimed to be married, in order to defeat the case he brought against her, she had testified she was not married and would never marry him. And so we got that reversed. We claim it was a divorce, even though they were never married. Again, so you never know how that rule might come in handy. Okay. Federal court responses. Are these easier or harder? Harder. Okay. First of all, when the other side moves for summary judgment, we are talking about responses, they need to cite in a statement of undisputed material facts every fact they intend to rely on to justify summary judgment. It can't just be included or mentioned in the brief. It needs to be every fact that's relied upon in order to actually grant summary judgment. And in the response, what do you think you have to do in your statement in response to the statement of material facts?
You have to respond to every single issue that you're contesting, or else you'll be found to have waived your right to oppose it.
Yeah, to use that fact. In fact, they say that the judge said, the rules say that if the movement, the court will deem the movement citation of supportive of its fact unless the respondent specifically informs the court to the contrary. So basically, if the movement says this is what the fact is, and the respondent doesn't specifically reject that fact and cite the reasons why, incompetent evidence, and all the different ways we've discussed, then the court will deem that fact to be established. And so in this instance, I know for sure you have to actually respond to the statement of undisputed material facts item by item? What if the movement throws in all sorts of excessive and extraneous facts? Do you have to respond to every one of those?
You can register an objection, right, to relevancy.
All right, so relevancy, or I guess you could do an objection. You can say either that's not material, or for some reason it doesn't meet the requirements of admissibility. But what if it's really bad, but not material stuff? You might want to contest it anyway, right? And the court might get upset at the other side for putting in a bunch of junk into the record. It's hard to say. But we know for at least every material fact, the respondent has to directly address with competent evidence and good citations each such alleged fact. Now, what if the contesting of the movement's material facts is not sufficient in your mind to actually defeat the summary judgment with the motion that's been brought against you? What must you do?
Your own statement of additional facts?
Yeah, there we go. And what we're looking at here, of course, is the local rules of in their most frequent instance, the local rules of the Northern District of Georgia. And in this case, it is local rule 56.1. And there are a lot of subsections we could quote here. The statement of additional facts is local rule 56.1, capital B, 2, little b. In that instance, that statement of additional facts has to be supported in the exact same way that the statement of undisputed material facts has to be cited by the movement. And then what does the movement have to do in response to the statement of additional facts if they don't want them to be deemed established?
Have to respond in the same way, right?
Okay, they have to respond under local rule 56.1B3. They have to respond tit for tat to the additional facts presented by the respondent. And there, as Mike has already mentioned, you can object to the admissibility or the materiality of the facts. Or and the admissibility could include a hearsay objection or whatever. Okay. But in federal court, and this specifically, if it's not even required by a standing order, what must you do with all the facts, all the supportive documents that give rise to your objection to the evidence? What do you have to do with those? You have to attach them as exhibits to your brief, which can be a royal pain if it's depositions, interrogatories, responses to requests for admissions, interrogatory responses, et cetera, the documents that are identified in depositions, et cetera. They all have to be exhibits to the brief itself, attached, right? And of course, that means these days doing the electronic filing of the brief and then all these different attachments to the brief. And what if it's big documents that you have to attach? Split it up. You might have to, but why would you have to split up a document?
Because the file size exceeds what the court will allow.
That's right, which is what?
25 megabits, I believe.
25 or 20 or 25 megabit. So that means you got to figure out way in advance whether the exhibits you're relying on are too big to be attached as an exhibit. And then you have to divide those into sub exhibits. Another thing that a court might require you to do, and how how much space do you have in a response to summary judgment in federal court to place reference to all your legal arguments, all your exhibits, and all your contested citations of fact?
20 days?
25 pages. And it's in 14-point type, right? Double space. So you can end up with a huge challenge, I guess is one way of putting it, to have all this stuff crammed into 25 pages and then with a whole ton of exhibits. Especially if you're trying to actually quote some of the responsive material, et cetera. So what can you do if you think there's no way in the world you're gonna get it 25 pages? Yes, ma'am.
You can ask opposing counsel if they consent to an extension of the presentation and then file it with the court. I've seen the court allow it a lot of times, but to my surprise, I've seen the court say no as well.
Yeah, so, and that would have to be by joint motion?
Yes.
Okay. And what happens if the judge decides no on the 29th day?
Just have to be prepared.
Yeah.
That might happen.
Yes, so and that does happen where the judges don't necessarily turn around and respond to requests for additional pages right away. And then you essentially have to have two versions of your brief go, I guess, or figure out in advance what you can cut out if you absolutely had to. Okay, I believe we have also had a court in her standing order require that all the documents that you attach as exhibits be OCR'd for searchability. Does that sound familiar? And what does that take at a minimum in order to make all that happen? Additional time in preparation, right? Because you have to not only have it small enough to be attached as an exhibit, you also have to have it small enough as OCR to be attached as an exhibit, and you have to have it somewhere if it didn't come in an OCR version, you have to have it somewhere segmented out in order to attach it to your brief when you file it. Now, how about this? Do you have to attach the entire deposition you're relying on as an exhibit to your response brief? All right, I see a shaking head. That's correct. In federal court, you only have to attach that portion of the deposition that has the testimony that you're relying on to give rise to the genuine issue material fact. That's local rule 26.3B1. Does somebody have to file the entire deposition that you excerpted in your response brief? Yes, okay, we have a yes.
Whoever has the original transcript.
Okay, so yes, whoever has the original transcript has to file the entirety of the deposition electronically. And similarly, the rule says you need to, and that's a local rule. I hate the way they do this. In state court, everything is little b first, and the local rules, everything's big A, big B first. So this is local rule 56.1 C. States what the exhibits are and how they have to be attached. But all this can't be done at the last minute. If you got to do the sizing of the exhibits, the OCRing of the exhibits, the selection of the exhibits, the segmentation from the larger discovery documents, etc. You need, if you use interrogatory responses, and let's say only one response out of a 50-page document, should you attach the first page and the verification
Yes,
as part of that? Why the verification?
because that's the sworn testimony, and if it's not sworn, so it's not going to be admissible.
Okay, and what happens a lot of times in litigation people send their interrogatory responses and never swear to them, right? Which means along the way, in anticipation of using those discovery responses to respond to summary judgment, what do you need to do with the other side if they don't verify?
Motion to compel.
Or somehow harass them, yes, harass them into giving a verification. Okay, how about this as part of a response? Let's say you're limited to 25 pages. You sought to get additional pages somehow or another, either on your individual motion or by some consent on the side. And let's say you have multiple defendants that are all had motions for summary judgment filed against them on the same subject matter. Can the defendants divide and conquer with one defendant handling one topic, another defendant handling another topic, a third defendant handling another topic, and each of you spending 25 pages on your individual topic? The answer is risky business, very risky business. If you do want to rely on some other co-parties, which of course would require you knowing in advance what these people are going to say, right? Some sort of joint effort. If you're going to even think about relying on somebody else's brief to support your response to a motion for summary judgment, what at a very bare minimum would you have to do in your brief?
Adapt their arguments,
And you'd have to do it by adopt their argument by what means?
incorporating it into your brief.
Okay, you'd have to adopt their arguments by incorporation by reference and, according to some judges, at least summarize, maybe cite the principal case that they relied upon. Basically, you need to cram as much in there as you can while doing all your other arguments to make sure that if anything is incorporated, at least you have the absolute core response that the other side the other defendant, the other party is briefing more thoroughly. Because sometimes courts focus more on what's easy for them than it is what's really right for the parties. So if it's easy for them to say, all right, well, that topic just wasn't covered in this brief because all it said is I incorporate defendant XYZ's brief. So you lose on that issue. Okay. So we didn't even talk about the law part of the brief. Can you use AI to generate all your responses? All right, so we've covered that. We've covered that in the past. Now you have to, with respect to all the legal issues, you actually have to have verified, thoroughly researched, and properly cited responses. And how about a statement in federal court? What about a table of contents? Have to do that. How about a table of authorities? So if you really, do table of authorities fall within the 25 pages? I don't think they do. Anyway, so there are a lot, if you're going to do a summary judgment response brief correctly in federal court, you got to do a lot of components. Is a table of authorities actually required? I cannot remember. It's a nice thing to have. But does anybody know if a table of authorities is a mandated portion of a response brief?
I don't think in federal, I think in appeals court it is, but I don't know if federal court.
I think you're right on that. I don't see it listed as a component. So it'd only be if the judge required it, and then hopefully, like I said, it would be excluded from the 25 pages because that can burn up a lot of pages just in and of itself. Okay. Anything else for the good of the order with respect to response to summary judgment, either in state court or federal court?
The page limit rules usually don't include the pages for the tables, do they?
I don't think so.
Yeah.
I think they'll, and usually they're little I, two little I's, three little I's, so it doesn't. How about your footnotes? Can your footnotes be single spaced and in 10-point type? I think not, which makes it hardly helpful sometimes to try to drop a lot of your brief into the footnotes. And so to me, that's the really tricky thing. You can have great arguments, but somehow you have to cram it into very limited. How about this? Can you argue your response to summary judgment orally? All right, you have to request it, and who can request that in the Northern District of Georgia? Can I request that? I can request that. Is there any requirement for anybody to give it to me?
No.
All right. Do any judges have any requirement for anybody to be able to argue the responses to summary judgment orally?
We let younger attorneys do it. It's their first time, or they've never argued in front of a judge before, but of course, there's a preference to do that.
Okay, so a number of judges have standing orders that say, and the way I've seen it, it's gonna be different per judge, but if the lawyer has been practicing for 5 years or less, maybe it's less than 5 years, they will give serious consideration to them being able to argue their response to or argue the summary judgment motion, whether it be the motion or the response. But we, using creative stuff one time, I found a 20-year lawyer who had only been practicing for 5 years or less because he had been a trustee lawyer at a bank in California, even though he was a Georgia lawyer. And then he moved into town and started up a law firm. And we were able to get the judge to allow him to argue it. That was the tantalizing thing we dangled in front of the judge, saying, please let this old lawyer who has never argued anything argue. And the judge did. And the great thing was he won, and he concluded the argument with, it was this plaintiff from Texas, send them back to Texas. And he did. The judge sent them back to Texas throughout their case. Okay, anything else? Thank you all very much.